Good evening, everybody. Welcome to today's session. You planned your move. Did your estate plan come with you? Welcome. My name is Zara. I'm a lawyer. I'm based in Saudi Arabia in Riyadh, and I will be monitoring and moderating today's session. So, just so that I can give you some housekeeping first before we move on to the webinar. Like I said, I'm based in Riyadh. We have one of our panel members, Basim, who's based in Dubai. Joining him is also Dominic. He's based in the UAE. And then we have another panel members. We have two more panel members based in Saudi Arabia. So just wanted to highlight to everybody the international audience that we have and the accessibility across multiple jurisdictions. Just for your awareness, please note that today's session is being recorded. And once the webinar is complete, the recording will be sent to all registrants once it is ready later this evening or tomorrow. Also, could I please request that as we move throughout the session, all questions are left to the end, and that any questions that you have are put through the Q&A, the question and answers chat. And as they will be coming up, I will be recording them. And at the end of the session, the panel will address those questions which we received at registration and those questions which we get through the session. I just wanted to also let you know that this is not an advice session in any way. It's just purely an educational presentation webinar that is being provided for Canadian expats who are based in UAE and KSA. And just finally, anything that is provided is confidential. Please don't share it with anybody outside of this room. It's purely for those people that have registered. So on that note, I would like to introduce you to our panel this evening. If we could have the next slide, please. Thank you very much. So for everybody, let me introduce you to the panel that we have. We have Basim Fawzi, who is the Vice President of MENA at Alexa Wealth Private in DIFC. Alexa Wealth Private, for everybody, by way of background, is a DFSA regulated wealth management firm based in Dubai International Financial Center, and it specializes in cross-border financial planning for internationally mobile professionals and families. Basim has over 30 years of financial services with a particular focus on Canadian expats navigating tax residency, estate planning, and investment structuring across the GCC. By way of background, Basim holds a Bachelor of Laws. He is a Fellow of the Canadian Securities Institute and is one of the highest distinctions in the Canadian financial services in the Canadian financial services world. He also holds a Personal Financial Planner designation. I would also like to introduce to you the remaining panel members. We have with us, before Basim begins, we have with us Dominic Athwell, who is a partner at Ogier in Dubai and is an England and Wales qualified lawyer who specializes in Cayman Island investment funds. He advises hedge funds, private equity sponsors, asset managers, and family offices on co-funding, structuring, formations, regulation, and ongoing operations. He has a particular focus on the Middle East clients and cross-border matters. Dominic is also recognized as a key figure in Ogier's regional fund practice, and he's known for commercially astute, responsive advice for his expertise in complex, multi-jurisdictional fund structures. And for Saudi succession, we are joined by a team from Mazen bin Abdul Wahab Kurdi Law Office. By way of background, Mazen bin Abdul Wahab Kurdi is a Saudi lawyer and a Ministry of Justice appointed arbitrator with over 2 decades of legal practice. This includes leading the Kingdom's legal team on international aviation emissions policy at ICAO and memberships of lawyers' committees at the Makkah region. He holds a master's in law from King Abdulaziz University, and he is an honorary doctorate in ethical entrepreneurship from the Cambridge International University. He is also the author of 2 published books, including Legal Principles Governing Civil Aviation. With Mazen are also Bayasher Bagdi. She is a licensed lawyer with proven experience in litigation, legal drafting, and contract advisory. She manages cases, prepares high-quality legal memoranda, and supports dispute resolution strategies. She is recognized for strong analytical judgment and meticulous attention to detail. And finally, but not last, is our final panel member, Jury. She is soon to be graduate of University College in Dublin with a Bachelor of Business and Law. Her dual focus on law and business has built knowledge across legal disciplines alongside practical exposure to legal practice, strengthening her legal research, analytical reasoning, and commercial awareness as she moves towards postgraduate legal studies and a career in the profession. So all of our guest speakers join us independently in their professional capacity. We welcome them. We welcome all the guests in the audience, and from that, it's over to Bassem. Thank you very much.
Thank you, Zahra. Thank you very much. Good evening, everyone. I'm Bassem. Some of you here have followed my work or joined earlier sessions, and some I've worked with directly. So you'll know what I focus on. I focus on closing the gap in cross-border planning for Canadian expats and building an ecosystem of professionals to serve it. Tonight is no exception. That gap runs across 3 things: taxes, estate, and how assets are being held. Generally speaking, these are the gaps when we become international people living outside of Canada. Those are the things that we need to bridge most of the time and we need to plan properly. So tonight is about the last one, is about the estate planning and how we're holding the assets. But before we start, my thanks to my guests for giving their time to be here this evening. Thank you very much for everyone. So like I always say, you planned your move, but did your estate plan come with you? So you spent your lifetime a career building, and you came to the Gulf, but almost no one that I have met have put in the time to plan what happens to anything that they built if they die here, or when they die anywhere in the world when they have assets outside of Canada. The plan that most people have was written in Canada. That's if there is a will, and you'll be surprised that, still some people, they haven't gone to it. They always say yes on top of mind. But again, when they do, most of the time, this is where it stays. So what is it that we're dealing with today? And I have to give you the heads up, by the way. I'm sorry, I should have said this earlier. Tonight, we are going to cover lots of grounds, okay? And things might get a bit confusing at some point because you will realize that we're going through different jurisdictions, different holdings. We're talking Caymans, we're talking Saudi, we're talking UAE, and so on and so forth. So bear with us. We'll try to make this as simple as possible, very well connected as possible, and we're always here to support you when you have any questions. But from the face of it again, what are the jurisdictions that where a typical Canadian expat has assets at? In Canada, you have your registered accounts, you got your RSPs, you got your TFSAs, your non-registered investments, and perhaps you have a property or two, whatever, some real estate portfolio. Now you have in the UAE and Saudi, I'm going to interchangeably refer to UAE and Saudi for the time being because of the majority of similarity on both. But then again, the differences will come to the specialists in respective jurisdictions. However, you have your bank account in Saudi or in the UAE. You work, this is where your salary goes. And from there, you would have maybe you have a property, have your rental property, or you bought your own property. And then you have some investments, perhaps cash saved within the bank. And then the surprising part, the United States. Well, people say, well, I don't have anything in the US. And well, apparently we do. And this will be a surprise for some of us. And we're going to talk a lot about this today. This is your US stocks, your US, but your portfolio of shares. You got the Apple, the Tesla, the Microsoft, and the such, and you have them with Saxo, IBKR, or whatever the case might be. Those two on death, this is actually form a part of U.S. Estate tax bill when we will get to this. So what you own, okay, what matters is what you own and where it sits. So it's not what you have, is where it sits, where it is actually registered. Okay. So we'll get to this here. So you look at your Canadian holding, and I'll explain why this make a difference. So your Canadian holding, you have again, your register plans. Typically for estate planning purposes, you would have appointed a beneficiary on that plan, be it your spouse, or if the spouse is not there, maybe you put it for your children. Anyway, you have that option for the funds to pass on to someone that you designate. It's a straightforward. Now you have your non-registered portfolio. Again, this rolls under your will. How this money will be passed to the next, it will pass through your will. Then we get to stop here at the local UAE and the KSA. So you have your bank account, property, as we said, and everything here falls under the local succession law. So you notice here different types of accounts. So you have Canada, the succession law in Canada prevails how the assets rolled over, be it beneficiary or be it through will. UAE and Saudi Arabia, different story. Canadian will does not work outside of Canada. Then finally, you have your Canadian real estate, which again, it falls under, it passes by a will unless it is joint, it rolls to your spouse. So each asset answers to its own jurisdiction. And we need to focus on this point because if there's something that you need to take away today, is each asset answers to its own legal jurisdiction. So there is no one size fits all. There is no one umbrella that can covers everything. So you have your Saudi bank account that falls under the Saudi law, and the UAE, the same thing. And then you get the US listed shares. This form a US situs. Wherever your account is held, it doesn't matter. For as long as you're holding those shares for American companies, they fall under the US estate tax. So as we said, so I hear this a lot. My brokerage account is in the UAE, so my investments are UAE assets. That is wrong. The true story is your US, as I said, this one to me, and you can hear me saying this, and you can hear everybody referencing the same issue as we move along, because it represents a big part of the biggest tax bill that can be subjected at some point. So the US listed shares inside an account is a US asset for estate tax, no matter where your account is. And something here on the slides, I know there's a point that we touched on, but it's not as deep as I should have. And I'm going to take a moment, I'm going to address this. So I'm going to stop on this slide for a moment. A US person has an estate tax relief or credit up to $15 million. So $15 million of saved of US state citus assets are protected. You as a Canadian resident, or we as Canadian residents, we also enjoy similar because of the treaty. So we have that relief. So as a Canadian resident, your estate is protected up to $15 million in the event of the passing of the account holder. Once you become non-resident, then you become you're a you're a non-resident, so you default to like anybody else in the world, which is the protection is $60,000. So the $15 million are lost once you become non-resident, and that give you a much bigger exposure because you only protected at $60,000. These are two numbers you need to hang on to those. We'll come back to it later. So moving on, another thing that also that you're paying while you're holding the U.S. assets. I'm sure if we're in the room, I'll ask how many in the room, like show of hands, have signed the W-8 ban, and this most of us are familiar with it, and if we're not, then we have a problem. This is what tells the U.S. Your residency status, right? And it reduces your taxes on a dividend to 15%. Okay, so the U.S. state takes 15% of your dividend for taxes for that. Otherwise, it can be at a 30%. So that form handles only that the tax part has nothing to do with your estate plan. Some people think it has something to do when I die or something. No, it doesn't. I've heard it before. So what is it? What in the U.S. What is it actually that they tax? The U.S. listed shares, the Apple and the such. Your U.S. domiciled ETFs. So your ETF, like you have, like QQQ, for example, is that it's tracking the index and it's U.S. domiciled. It falls under the same thing. Or assets held directly in your name. What is not being cited as asset? You can actually hold the same ETF that tracks the S&P, right? But is Irish domiciled. It's Luxembourg domiciled. Those ones, even though they're holding assets in the US, they don't fall under the US cited assets, and hence they don't fall under the US estate tax. Like as I mentioned earlier, so as a US person or a Canadian resident, you have a 15 million exemption. So your assets up to 50 million on death, that's exempted. As a Canadian resident, there is a relief that can take you up to 15 million. As non-resident and a non-US person, you only get a 60,000, it's called allowance on US cited assets. Now, how to calculate this? The tax rate, I'm not sure if we addressed it here or not. The tax rate, which is the biggest really, it can grow up to 40%. So I think at 1.1 million, it hits the 40%. It's a graduated rate. So at 1.1, this is the top rate, and anything above that is 40%. And that actually not on your capital gain, not on your dividend. This is on the actual capital that's there. So here, which is a typical portfolio, I'm assuming, in this room, holding a 500,000 portfolio, on death, the U.S. estate tax could be up to 135,400, right? Then it can grow up to 40%, but that's not the case. But it is substantial. So what are the issues when it comes down to this? The issues with the U.S. cited assets, that at death, the cited assets reach a choke point. The choke point is this. The executor will reach to the broker, and by the way, that will fall under, sorry, I forgot to tell you this. You need to check with your, if you have a broker, like if you're with a DS or a TD or CIBC with Dundee, whoever, you may want to check with them because even your assets in Canada can fall under the same thing because you're no longer a resident. If they have you as non-resident, please consult with your advisor in Canada and get this clarified because you don't want to leave this to the surprise or to a chance. So what happened at death, the executor will walk to the broker and communicate with them. However, Mr. X passed, and here's the certificate, and we understand, and here's the will, and just basically they need to deal with the money. They have expenses, they have funeral cost, life anyway. The broker will immediately freeze the account. That's anywhere anyway, and will request clearance from the IRS. The IRS need to clear, they will say, okay, this calculation, you have to pay us this much money. Then someone somehow will have to pay this money, so the IRS release the the account. Now, the account is frozen and cannot be released, so you cannot pay from within the account. So it's a choke point. Now, again, as Zara said earlier, this is not an advice event. Those advice is the advice given on one-on-one. This is just for general education only. So that's what happens. So you got the choke point that funds are frozen and there's no way out until this is paid. So obviously in the planning, there's always have to leave money outside to pay for the estate. Okay, so we covered the Canada Treaty. This one is covered already, so we didn't need to go there. And as we said, your local assets answer to the local law first. And so local held assets in the UAE succession proceeding, it's not your Canadian will. And in the UAE, however, okay. So the succession law, first thing happened once the account, someone dies, the account is frozen, and until the court decide what to do with the funds according to the family or succession law in the UAE. However, in the UAE, there are options, there are mechanisms that one can opt and go and register a will, be it in DIFC or in ADGM, and that gives a will and let your intentions know what to do with the money, and that obviously avoid a lot of surprises, and what you want to get done, and you put this documented, and your family is comfortable and everything goes smoothly. So again, I go faster a little bit. So again, local accounts be frozen until the succession is resolved, and the family again left with money stuck until the court decides. So again, Canada will does not cross the border. And at this point, I'm gonna turn the room over to our friends and colleagues and partners at Mazen bin Abdul Wahab Kurdi Law Office. Over to you.
Thank you, Mr. Bass. Okay, let's start. Good evening, everyone, and hello. Just give me a second. Okay, I think my mic is. Do you everybody hear me clearly?
Yes, we can hear you very well.
Okay. Okay, good evening, everyone, and welcome. We're delighted to have you today with us and appreciate taking the time to attend the seminar. We hope the session will provide valuable insights and knowledge with a better understanding of the inheritance regulations in Saudi. Let me introduce myself first. I'm Bashayr, a lawyer here in Mazen Security Law Office. I'm practicing law for almost now 4 years. Our firm is recognized as one of the leading law firms in Saudi with more than 30 years of experience and delivering comprehensive legal services and counseling. We serve different range of clients, including consulates, embassies, international organizations, corporations, and also individuals. We represent our clients in a very wide range and different type of cases and disputes before judicial and semi-judicial authorities. In addition to litigation, we provide legal opinions and advisory services, as well drafting and reviewing legal documents and contracts. We are committed to delivering effective legal solutions with maintaining the highest standards. Okay, let's begin. An inheritance in Saudi is governed by the Saudi Personal Status Law, which is based on the principles of Islamic Sharia, which means that the shares of the legal heirs are prescribed by the law, ensuring that the estate is shared among the legal heirs accordingly to Sharia. This law is equally applicable to all citizens, residents, and regardless of their religion. The distribution of the estate depends on who are the legal heirs and the relationship with the deceased. Can you go to the next? Yes. Let me give you an example. Let's say there's someone passed away, a man passed away with leaving his wife, his son, and daughters. In this case scenario, the wife receives 1/8 of the estate, and the remaining of the estate is distributed between the son and the daughter, with the son receiving a share of equal to halves of the daughter in accordance with the Islamic rules of Sharia. Now I'll give the mic to Juri.
Hello. Now that we've discussed the rules of inheritance under Saudi law and who's entitled to inherit, I would shift the focus from who inherits and how an estate is actually administered in practice. Many people would assume that once a person passes away, the estate immediately divides amongst the heirs. However, under the law, a structured legal process must be followed before any distribution takes place. So, after the person passes away, the next step would be identifying all assets, including the real estates, bank accounts, investments, vehicles, and any other assets owned by the deceased, establishing all assets before any distribution can occur. Once the assets has been identified, the estate administrator must ensure that the funeral expenses are paid. After that, any unpaid bills, debts must be resolved before the creditors are entitled to get paid, before the heirs receive any inheritance. If the deceased has left a valid will or a wasiyah, that is considered and implied in accordance with the Saudi law. Only after these steps have been completed, the remaining estate distributes among the legal heir according to the prescribed inheritance share under the status law. There was a practical question that we received was, what happens if property estate planning has not been carried out? In these circumstances, the process can become more complicated, as in identifying assets would take longer, important documents may be missing, or disputes between family members are more likely to happen, and the overall administration of the estate may delay. This is why proper estate planning is important. While it does not change the inheritance rule, it helps to ensure that the administration process is efficient and straightforward as much as possible. So now that we looked at the process, let's look at the role of the will that plays under the Saudi law. If we can go to the next slide, the Saudi law recognized as a wasiyah, which is an Islamic bequest allowing that the person to determine the distribution of their estate. However, unlikely many common law jurisdiction, a person does not have complete freedom to dispose their entire estate through a will. As in, they can only, it's the wasiyah limits only to 1/3 of their net estate, meaning that the remaining of it would be expenses, debts, or how they've been handled. In addition, it can benefit individuals who are not part of the legal heir, such as charities, friends, or other beneficiaries. If someone wishes to leave part of their estate to a legal heir, they will request to consent all the remaining heirs after the death, and this brings the common question that we received: how can I prepare and register a will in Saudi Arabia? So the first point is to remember is that any will dealing with assets located in Saudi should comply with the Saudi law. A proper drafting of the wasiyah should be there. It identifies the assets, the intent of the beneficiaries, and the remaining of the legal limits, which is the 1/3 of the prescribed under the law. For individuals with assets in Saudi, legal advice is highly recommended to ensure that the will is properly prepared and has been through the appropriate Saudi legal procedure. The proper drafting, registration can reduce very uncertain problems and can help to ensure that the procedure is going smooth. With that in mind, I would like to discuss a few practical considerations that can make the estate planning more effective. So first off, in Saudi, everything at the moment is biometric. as in everything is electronic assets, like everything's going through the system. We have systems, everything is electric. So having electronic asset registrations, it would help the procedure that I mentioned by simplifying the identification, the verification, and the transfer of property following a person's death. The more organized the state is during the person's life, the more efficient the administration process will be. Another important consideration would be the cross-border estate planning. As Mr. Bassem mentioned, that if a person owns, an expat owns or like has properties throughout places, many expats live in Saudi and they own assets in more than one country. As a result, of course, there are different legislation and systems that may apply to different parts of the estates. Planning ahead helps to identify issues earlier to reduce the delays and the conflicts that would occur. As well, maintaining a very clear documentation and accurate record keeping for the documents of the ownership and supporting records help reduce disputes and allows the estate to be administered more effectively or efficiently. Finally, another question we received is, how do my assets transfer to my spouse? The answer depends on several factors, including the location of the asset. Does it have any legal application, or what's the system that we can use, whether the assets are located in or outside of Saudi Arabia. Although Saudi does not impose any inheritance tax, so many expats would own in several countries, these assets remain subject to the law of the country where they're actually located. For instance, if we have a Canadian living in Saudi and they might own a property in Canada or they invested in the States, each of them would have their own legal and tax system that is going to go through the process upon their death. That's why cross-border estate planning exists. Moreover, good estate planning is not simply about preparing for the future, it's about protecting your family, reducing uncertainties, ensuring a smooth and effective or efficient transfer of the wealth across generations. So it depends on what type of assets the person has. Are they a bank account, shared bank account, or are they cars, estates, land? So it depends on what it comes to, because there's a regulation and legislations that are going to go through every and each system. And we're going to go back with Bashayed just to wrap up the entire thing. To the next slide, please.
Okay, key takers. Saudi inheritance is governed by personal status law and Islamic Sharia principles. The law provides a structured process for the state administration before, sorry, the slides went out. Mr. Bassem, the slide, please.
Are we good now?
No, it doesn't agree.
Okay, what are you seeing on the screen now? Is it a black screen?
Yeah, it's a black screen, yeah.
Black screen. Are we back now?
Yes.
Yes, we can see the slides, but they're
Good.
not, yeah.
That's fine. Sorry about that, everybody. You good now?
Yes, but if you can go
Can you
to the
go
slide
back?
before that.
Oh, sorry.
Thank you.
Okay, just to wrap everything up, key takers. Saudi inheritance is governed by the personal status law, Islamic and the Islamic Sharia principles. The law provides a structured process for state administration for the distribution of the inheritance. Legal heirs are protected through prescribed inheritance shares. Wealth, as Mrs. Judy explained are recognized with specific legal limitations.
And as I mentioned, the proper documentation and asset registrations help reduce disputes and delays. Early estate planning helps to protect family interest and facilitate succession. Saudi does not impose a general inheritance tax. And thank you. And we will take questions at the end.
Thank you for listening.
Thank you, Bashair. Thank you, Jory. All right, so now we've been through not bad news, but I mean, the process that this is exactly what happened without the planning. But now, what's in our toolbox? How can we mitigate the certain risks or perceived risks in the holding? So now I'm going to turn the room over to our friend partner, Mr. Dominic. Mr. Dominic, take it away.
Thank you, Bassam and Bashir and Jory. Fantastic listening to you all so far. So good evening, everyone. Quick introduction. I'm a partner in Osia's Cayman Funds team based in Dubai. And as mentioned earlier, my practice covers quite a broad range of topics, but it involves advising and structuring on Cayman funds, but more so over the last couple of years, particularly being based in the GCC, the ongoing operation and setup of holding companies to structure personal and private wealth. So next slide, please. So I think what we've essentially seen so far is some of the potential problems that can face clients. So essentially, you could be an expat in the GCC. You have assets in across multiple jurisdictions, whether it's Canada, the UAE, in many cases the United States, and in each of those jurisdictions, there are rules that apply upon your death, whether it's in your home jurisdiction where you reside or where the assets are based. And I think it's probably fair to say there isn't a single document that ties all of this together. So, for example, your Canadian will might not reach your UAE assets. There are no documents which would necessarily solve the US exposure. And I think that's the gap that has been highlighting. So what I'm going to try and focus on is one part of the potential solution, a structure. And the core idea is very straightforward. So instead of trying to change how the laws that apply to your assets, we're looking at how you change how those assets are held. Sorry, could you just go back to slide 32? Yeah, that's perfect. So, okay, at a very high level, a Cayman holding company does three things. So firstly, it consolidates ownership. So instead of holding different assets in your personal name across different jurisdictions, so you could have a brokerage account in the US, a property in the UAE, a bank account somewhere else, you bring them under one legal entity. The second, it gives you flexibility in estate planning. And I'm into some of that detail shortly. But essentially, you're no longer transferring or thinking about transferring individual assets across multiple legal systems. Instead, you're dealing with the shares that you would own or your family members would own in one Cayman company, which in turn would hold the underlying assets of the family or of the matriarch, patriarch, however these things are structured. And I think third, and it's probably the most important from a Cayman perspective, is that Cayman companies are widely understood and accepted by banks, custodians, brokers, administrators, and there's lots of professional advisors practicing Cayman law. So I think in a cross-border context, that familiarity is critical because it means you're not introducing an unfamiliar or a bespoke structure to your wealth that needs to be explained or analyzed with all of these different service providers and counterparties. And I think that reduces the friction in establishing the accounts, executing transactions, and dealing with succession events. So if we go to the next slide. So, I mean, there's lots of sort of complicated legal concepts that I'm going to try and cover, but I'm trying to do it in a way which hopefully helps you give you the overall picture, and then we can move to questions. So I'm going to try and gloss over some of this, but again, we can build deeper and on the answers and anything you may have that comes out of the questions. So the the first one, why, having your assets held through a company can start to solve the cross-border problem, is because of centralization. So if you hold assets directly as an individual, each jurisdiction, as I mentioned earlier, will apply its own succession rules when you die or when you maybe pass away. So if these assets are held through a Cayman company, the primary asset that you will hold becomes the shares in that Cayman company. So if the worst were to happen, we wouldn't be considering, okay, well, how do the shares in this company that I held, or how does the property that I own? We wouldn't be asking those questions. We'd be asking, well, how do the shares in that Cayman company properly pass to your loved ones or the people you want the shares to be passed to? So rather than transferring individual assets across 3 or 4 legal systems, or maybe more, you're looking at transferring one asset, the shares in the company. And I think that's what simplifies succession and reduces fragmentation. So if we go to the next slide. So the next point is really around flexibility and why a Cayman company or a Cayman holdco or even any Cayman vehicle could be very useful. So because you are now dealing with the shares rather than underlying assets, you have a far greater level of control over how the ownership is transferred. Now, there are many ways I've seen this done. So by no means what I'm saying here is the only way. But what you can do is you can actively manage the succession during your lifetime. So for example, you set up a Cayman holding company. One option would be to be simple. You are the owner of all the assets, you transfer it to the holding company, you have all the shares, and when you die, the shares will be subject to the probate laws in Cayman, and that will decide how the inheritance is going to be governed. Equally, you could have the same company, and on day one, you could have shares issued to yourself, so you have all the voting and all the economics into that vehicle. But you could give your children shares over time, or you would give them all the shares on day one, but the rights attaching to those shares increase over time. So I think what a Cayman company does, and the fact it's essentially a jurisdiction which is based on English law, it gives you a lot of flexibility in how you structure these holding companies. So I have set up many for clients in the GCC, and I would say the one recurring theme is that they are all very, very unique. There is not one central theme in how these can be set up. And I think importantly, the approach can evolve over time. So I think that can reflect changes in family dynamics, residency, or the underlying asset classes. Because again, for certain asset classes like equities that are listed on the stock exchange in the US, a Cayman company can be extremely flexible. But for other assets, you maybe have to think about where those assets are located and how flexible it can be. So I think, again, it's not just about what happens at death, it's about maintaining flexibility throughout your lifetime. So next slide. So I think I touched on this a little bit in
you did.
Yeah. But the key is, again, you are in control of the process. There is no one size fits all here. You tell Bassem, you tell the team in Saudi, you tell myself that you want a holding company. We can help you build these things based on your requirements. Another very important thing about having a company is that from day one, you can define who is making the decisions, who is participating economically, and how those rights evolve over time. And again, what's quite important here is that often the patriarch or the matriarch of families, when they're setting up their wealth, they actually want active participation by their children. So you include them as directors, you include their share classes, which have voting rights. I think, again, that is something which is quite unique and something that's often overlooked from a traditional structuring perspective, where lots of people think that it's a case of, I will manage everything until I pass away, and then on death, everything will go to my family. These structures allow you to manage that wealth throughout the lifetime. And I think that's why we see lots of GCC families and groups coming to us for these types of structures, because it offers maybe a different and maybe a more flexible approach than some of the jurisdictions where their assets are located. I think, sorry, there was just one last point on the last slide. And I think a key one here is around, conflict mitigation and planning. Now, I think historically, what I would say is that fund structures, holding companies, generally have always been very good at dealing with conflicts between different shareholders, directors, and shareholders, because it's inbuilt into the constitutional documents of a company. So lots of clients are moving more towards these structures because there is lots of case law in Cayman and other jurisdictions of how those kind of conflicts can be resolved. And I think that's, again, a very appealing part of having a company, a Cayman holding company, because it allows people to be confident that if there were to be certain disputes or certain issues, there is a precedent and a case law of how they would be handled. Thank you. So yeah, the next slide, please. So I think, again, another key benefit of Cayman holding companies is their continuity. So again, if assets are held personally, when someone passes away, it triggers a series of separate succession events. So, again, if you had assets in multiple jurisdictions, there would be essentially an event in each jurisdiction to determine how those assets will be passed on. By contrast, where you consolidate all of the assets into the company will continue to exist despite your passing. So the underlying structure does not change, only the ownership of the shares in that holding company need to be considered. So from a practical perspective, that can make a lot of difference. And I think it essentially will help reduce a lot of disruption, what is already likely to be a very difficult time for the family. So I think the real benefit here is also not just legal, it's practical, because whilst Cayman companies don't attract any taxes, the practical elements of dealing with all of this during such a time can be very traumatic. But knowing that actually the company is going to continue to hold all of the assets and nothing's changed is actually very reassuring. So essentially it allows the platform which holds the assets to continue uninterrupted. So the next slide, please. So protection is an obvious one, and it kind of touches on all of the previous slides we've mentioned, but I don't want to repeat too much, but essentially the corporate structure that you put in place places a layer between the individual and the underlying assets. Now, that in of itself isn't necessarily a benefit, but I think from a tax perspective and a regulatory perspective, and again, subject to tax advice, there can be benefits or drawbacks potentially of an individual holding assets in their own name in certain jurisdictions. So I think the fact that there is that legal separation can be very beneficial, and that's why often tax advisors will recommend these types of structures. And again, from a regulatory perspective, there can often be obligations upon an individual by holding these assets. So it's important that possibly to hold it through a holding company could mean that those obligations are more an obligation on a company with limited liability rather than you as an individual, which may have unlimited liability. Okay, next slide, please. So again, I touched on this slightly earlier, but I really think it's important to flag, and this is the big benefit, I suppose, of Cayman rather than just any company, because any company in most common law jurisdictions will achieve a very similar outcome ultimately. But jurisdictional neutrality. Cayman is a jurisdiction which has been largely designed and geared up, and the whole jurisdiction operates on the fact that it's a place for financial institutions. So it's not likely to change its makeup anytime soon, and that's very important. Cayman has not got a history of being in wars, in protracted sagas, nothing like that. It's a very neutral jurisdiction that operates with no taxes. So it's something which is very important when you're thinking about your structuring, because you want that stability. It's a trusted international center, as I said earlier. A lot of the US counterparties run and operate through Cayman vehicles. So there's a lot of familiarity. So getting these things up and running, transferring assets to them is very seamless. Next one, integrated multi-jurisdictional planning. Again, Cayman is well used, well known, and we see lots of structures, whether it's with Saudi vehicles, UAE, DIFC, ADGM, Bahraini vehicles, they find ways to make Cayman work within their structures, and also Cayman works very neatly within those structures. So I wouldn't want people to be put off thinking, I just need Cayman or I just need a DIFC structure. They can have structures utilizing Cayman vehicles where they're needed within their wider structure if necessary. And again, finally, centralized global asset management. Cayman can be used as the vehicle to sit right at the top as the holdco for all of your assets globally, and it's one of the major reasons it's used. Next slide, please. Okay, so this slide, I just want to touch briefly on the practicalities, because ultimately any structure needs to be usable. So essentially the way it would work is you as an individual, holding a certain amount of wealth through various assets, cash, etc., would speak to people like Bassam, would speak to tax advisors who would design you an optimal structure. And it may be that Cayman is the right structure for you. At that point, we would look at, forming the entity, setting it up, using a registered office in Cayman to do so. And then we would prepare the relevant legal documents. Now, they could be transfer documentation to make sure the assets are transferred to the company. There could be launch resolutions, which would ensure that all of the regulatory obligations which may hit this company are properly documented on day one. Drafting constitutional documents to deal with different share classes and the rights attaching to them. And then probably some filings with the registrar in Cayman to make sure that everything is all done in line with what the regulator expects. But essentially, what I'm trying to get at is it's a very streamlined process. It's very well trodden path, and you can get these things up and running within 4 to 6 weeks from the day you first meet me or the firm to the day you want it set up with all the assets in there. So it's not a quick process, and I wouldn't want people to think you can just rush it. But there is an element of these things are very quick, very very fast and streamlined to set up if everything is in place and there's a rationale for having it. Next slide, please. So look, I think without going over the same points again, I think there is, the key messaging is a Cayman holding structure doesn't change, where your assets are located. That's where they simply are. But it does change how they're owned, and that in turn changes how they can transfer at death. So that's the common theme here. And I think if you change how the asset's held, you can potentially change how it then passes on to the next generation. Thank you very much.
Thank you. Thank you, Dominic. And absolutely. So I guess the common theme about tonight's discussion, it's about how you're holding your assets. How you're holding your assets dictates how you benefit of the assets and the next generation for passing on, or in a company structure, how even you operate your day to day. And the same spirit of the holding. Now we're bringing different. What's out there? What's the market has for audience like yourself, like our clients, basically. What the market has. So one of the other options, again, changing how the asset is held. Something called a portfolio bond. It's an insurance wrapper. It's another type of setup where in this situation you still own your Microsoft and the Apple and the likes. However, it's into a policy and you are the owner of the policy. All right. So in the event of the owner dies, well, there was no disposition of the assets, because a portfolio bond, you would already have structured a trust. It comes, the number of options that come, it's ready to go, has a trust attached to it and you can appoint beneficiary. Even the trust, it can be just upon my passing, assets go to my spouse, or full work, because there is a corporate trust that's going to administer that particular account after the passing. My spouse will get this much money. I have two children who are today are like 3 or 4 years old. I cannot give them anything before their age of 20, and I want them to get this money, 30% every so much. And however, between the age of 20 to age of 30, because if it's a large amount and you give your 20-year-old 10, 15, $20 million, I'm not sure if they are, at the maturity level to manage this kind of money. So you want to protect them as well. So instead of giving them everything all at once, it goes on different trenches. So it all begins with how this is structured. And in this case, in this situation here, it's called a portfolio bond or insurance wrappers. And you separate the ownership of those securities or these stocks from your name. It's owned by the policy and you own the policy. So this is what a portfolio bond look like. What you can hold in it, you hold everything. So if I have my shares at a broker and I want to move it into a portfolio bond, there is no sale and there is no disposition. It's just a transfer document. You transfer them from this account to that account, and you go on with your life as usual. Now, those you gotta understand the Cayman structure, a portfolio bond, and the upcoming option here, which is called a PPLI, a private placement life insurance. Each and every one is suitable for something and for someone, right? And it's not, again, not one size fits all. So if I'm setting up, a Cayman Island company, and I want to manage like $50,000, I'm not really sure if this will be something that Dominic will say, okay, or maybe this one is not going to say, okay, something in a lot bigger. So every option here comes with its own mechanism that works for a particular situation. So finally here, that one of the last option that we have, the private placement life insurance, which is a PPLI. Again, it's an insurance wrapper and it's an insurance structure where, without getting in too much or in depth of this particular side here, your premium is your investment capital. That's basically it. And upon death, everything is paid to the beneficiary. So there are many options to separate the ownership of your assets to mitigate the risk or perceived risk upon the departure of the account holder, and to ensure that what you want to achieve into your family or in your surroundings, or managing your assets or your wealth, these are the international tools that available through a fine group that like this one we're talking with tonight. So bottom line here, so 4 tools, the order. So we got the portfolio tilt for smaller amounts, and you really don't want to deal with the U.S. estate tax. So just in case, the easiest thing, just go for the portfolio tilt. You move your U.S. domiciled, and this is not an advice. Please don't take this as an advice. Each and everything here, you need to consult professional. You need to move. You can move your U.S. domiciled holding towards an Irish or Luxembourg domiciled equivalent. Now you remove the U.S. status exposure. We have our insurance wrapper, as we mentioned just now. We have the offshore holding structure, like just Dominic explained to us. And last but not least, a will. You need to have a will in every jurisdiction, right? Because they do not talk to each other. So for every jurisdiction where there are assets, the will need to govern that. And I've been through this already. This is just, again, a wrapping an example. We're a Canadian family, been in the UAE for the last 10 years. They have US listed portfolio at a 500,000, and a buy apartment, an RSP back in Canada, and 2 children. What the exposure is? This is to show you that there is not just one exposure. There's so many exposures. When you sit with Dominic, and when you sit with Mazen's office, or you sit with our office, you would find that it has to be broken down to smaller pieces. So to identify the risk, and where the exposure and deal with it accordingly. So in this case, got the U.S. holding, the U.S. status question for estate tax. You got the investment assets question, what form they're held in, the apartment, will or no will, and the two countries that what will cover each jurisdiction. So the whole picture is big, it's complicated, but it's always start with one step. And at this point, I need to turn the room over to Zara. Zara.
Thank you very much, Basim. Also, thank you very much to the panel members. That's been really useful from a practical perspective, given that there's a number of Canadian expats that live across. Both panel provided was both practical and gave us insights and live examples of questions and wealth planning, things to think about for tomorrow. Moving along, at the time of registration, all the attendees were given an opportunity to register questions. We did receive questions, and on that basis, we've got a number of questions that we would like to address now. We've also received some questions during our webinar live Q&A session. So let's start with the questions that were received during registration. I will read the first question, and I will let then Basim answer this. Question 1 was, how do I prepare and register a will in Saudi Arabia as a Canadian? Basim, over to you.
Very good question, and I'm going to turn this over to Bashir and Jury.
Okay. How to prepare and register a will in case A for Canadians. Usually a will is prepared as any state. You can prepare your will, you can write it down, then it will be reviewed by a professional, then it will be registered electronically through the governmental platforms. But with the specifications, as Mr. Jury explained before, there are some specifications regarding the wills in South.
I hope the answer did clear up the question. So it can be any type of will, handwritten, a document. It just needs to be revised by an expert, legal expert, professional, as we prefer, or like as the system sees it. So like when you try to apply it through the portal, it might get rejected if it was missing something. So when it get revised, they would check that everything is in there, as in, for instance, if you have an estate, you need to put all details, explain your estate, as in, for instance, if it's a land, you need to put the location, the address, the details all regarding the state, and then it would be registered and it would be known or like in your will. So whenever they check your ID number, they find that you have this property. It's identified.
All right,
Thank you
so
very
I'll
much.
take the last. Thank you, guys. So I'll take the last one, whether a Canadian will covers UAE or Saudi held assets at all. The short answer is no, and the long answer, seek legal opinion on that, because these are different jurisdictions. And you just heard, as you just heard now from our partners in Saudi, the will has specific requirement. The Saudi drafted will to be accepted has certain requirements. And if it doesn't meet the requirement, it will be rejected. The same very much is in Canada. There are rules to write a will. You cannot write a will based on something bad, right? If this, anyway. So each jurisdiction got its own rules and how you create a will. You need your intentions. Like a will is basically to let your intentions known to the executors to execute. This is on the Canadian side. If it's off that, it will be rejected. So long story. seek a legal opinion, and you will need to create two wills, one in Canada and one in Saudi or one in the UAE, wherever your assets are at. I hope that answers.
Thank you,
Okay.
Basim and the team. Okay, moving along. The second question we've received at registration was, how would your asset... Basim, I'll let you answer.
Of course. So the question is how do assets transfer to a spouse in the kingdom? And then again, assuming these assets are in the kingdom, they're not outside the kingdom because it's a different story. Remember, it's always is not where you live, where your assets live. This is the key distinction when we're having this conversation about the estate planning. For this part, again, I would look at Jory and let her take this one, take it away. Jory Arbashayer. How do assets transfer to a spouse in the kingdom?
Usually assets, it depends on the assets. It's basically, it depends on the assets. If it's a property, a bank account, as Judy mentioned before, a shared bank account, any property in estate. So it depends on the estate itself. There is different jurisdictions for each state. Yeah, you can explain, Julia, of course.
And it depends if it's inside of Saudi Arabia or outside of Saudi Arabia, because it would make a huge difference. So,
Absolutely.
as the example that I gave, if there's a lot of states, we would like to identify if it's here in Saudi, and then we'll take it over from there. And it depends if he wrote in his wasiya or will that he wants it for his spouse, but if it was written fully for his spouse, it cannot be applied because it's only 1/3 for wasiya. Therefore, it would go through a procedure. Yeah. It's a bit too complicated to just answer a question out there. It needs
Of
to have
course.
specifications to be answered, but short question, yes, you can transfer it to your spouse, but through a procedure, and it needs to have ticks or boxes to be checked for it to happen.
So, Jory, that will take me to the last question here. Like, how long the process takes before the family can access funds? Let's use a simple situation without lands and properties. I guess the person who asked that question mainly interested to know about bank accounts.
If it was all applied or it was all identified perfectly, it was all in the system, it wouldn't take long. I think it would take, Bashari would help me, you're more experienced in this. How long would it take if it's only bank accounts?
Okay, usually if it's a bank account, it's merely just you have to be identifying the heirs after paying the debts and everything, as we explained before. Then I think you have the access to his bank account, and you can just go to the bank, and they will explain how to just transfer everything in the bank account or the funds in the bank account to the legal heirs.
And would it take like more or less than 3 months, do you think?
It depends if
it all goes
there is
smoothly in the
yes,
perfect
there
scenario.
is if there's any debts or other legal things to
Entitlement.
do, first the debts will be paid, then the remaining funds will be transferred to his family.
Okay, so it's not really clear how long will it take. So we'll leave this and we will go back to the person who asked that question. Maybe we can have a chat with you. Okay, so moving on. My
Great.
favorite topic.
Yeah, moving on. So just
Mhm.
that the audience knows, there's been a number of questions that have come, and what the panel's done is grouped those questions. So the question I'm reading is the theme, and then the panel are addressing individual questions. So the theme for this section is, you hold US listed shares, what's your exposure? I will let Basim take over.
So holding US listed investment and wanting to understand the estate tax exposure. Right. So once again, we're not talking to a Canadian resident or are no longer a Canadian resident. So you are Canadian, you're a non-resident Canadian, and you are not a US person either. Your tax relief is 60,000 on the that, let's call it non-taxable amount of money. So at so at $1 million, you remove the 60,000 if you really want to get to the calculation. And if you want the schedule, please reach out and we'll send it to you. So it's a graduated rate, right? And it goes up to from like 5%, it goes all the way up to 40%. And that's from 60,000 up to 1.1 million. So holding US listed investment and want to understand the estate tax exposure. So it's pretty much you are fully exposed to the US estate tax minus $60,000. W-8 ban, why W-8 ban keep coming? W-8 ban already on file to protect you at death? No, of course not. This is just to pay taxes. That's basically the US know that you're not a US person, and so your broker did not withhold 15% from your dividend. The 60,000 threshold, again, the same thing. This is for the non-US person. So this is your protection. First 60,000 is not taxable, doesn't fall under the US estate tax. However, everything above that is subject, and it's a graduated rate up to 40% on the capital. It's not on your dividend, it's not on your anything. So $1 million, like, just keep simple numbers. It's not accurate, but just to put things in perspective, it's on $1 million that is exposed. Let's put it that way. Oh, Dominic, that's for you. How would a structure actually work for you? Understanding structure that separate legal ownership from your name in the region. Okay. How to structure across jurisdictions, which will or trust to best cover assets in both Canada and the Gulf. That question is a bit like Dominic and I, we can touch on that, but it's a bit deep. Dominic, I feel it's too deep to give you really deep answers on that, because it covers on both the structures that separate legal ownership from the name. We covered that, but how to structure cross jurisdiction, that's an advice level. Which will or trust to best cover assets in both Canada and the Gulf, again, that's an advice level. So I'll Dominic, you can have that part.
Yeah, sure. I mean, ordinarily the way it would work on my side is you would set up a Cayman holding company. Now, in just that Cayman holding company would then be transferred ownership of various assets. Then, depending on how you wish to structure the succession side of things, would determine whether you think a will is appropriate. So if you only issued one share class and had one economic owner, which was the matriarch, patriarch, or yourself, and there was no other share classes and no one else entitled to the shares in that holding company, you would want to put in place a will in Cayman so that if you passed away, the courts in Cayman know how to deal with your shares in that holding company. So if you did put a will in place, what you would then have is a probate process. Someone would need to go to Cayman and say, I am the rightful owner of these shares now that X has passed away. And then you would be transferred the shares in your name as part of the probate process, or your children would be passed the shares. And then essentially you would have the same holding company holding the same assets, but now with a new owner or owners. So that's how that bit would work. A trust, is a completely different structure, which is, involves a beneficiary and a legal owner and different considerations. They are also very useful, but they, I would say, are more a tool. I mean, again, it's very difficult to say further depending on the specifics, but again, they're just a different tool that you could use for this type of thing.
And Dominic, and if I may add to this, especially for Canadian non-resident, in fact, we held a webinar. I believe it was in about a year and a half ago, where it was actually straight about it was again another estate planning, and we discussed the trust, and my partner there was a tax lawyer, and that's what they do, and they warn about setting up a trust while without clear vision of your plans and your intentions, because the last thing you want, the CRA catches this. CRA is the Canada Revenue Agency that catches this as a foreign trust where things get pretty unpleasant from a tax standpoint. So when it comes to trust for Canadians, we always say, you can talk to us with Dominic, but then again, you need to run to your Canadian tax lawyer to get their blessings on whatever it is that we're going to do. Thank you, Dominic. I'm sorry I had to jump on this one because I panic when I see trusts and taxes like Canada. You're like 30 years doing this, that bites sometimes. All right. Okay. So do we have other questions there?
Yes.
Those are ones in here.
Yep. So we've received a number of questions, Bassem, in the live Q&As. The webinar's been going on. Some of those questions have been answered already, so I will let you direct how to go forward. And I'm also conscious of time, so I'll read through them for your awareness and how we direct it. Okay. So the first question that we've received is, can a Canadian registered will be amended to include all assets, liquidity, etc. in KSA and USA for UAE, for recognition and protection under Canadian law? The second part of that question is, for assets, liquidity, etc. in both KSA and UAE, do you require separate wills for each country, or is there a GCC unified will, especially for non-Muslims? That's the end of that question.
Okay. We touched on that question on different occasions or different blocks, but if I put them all together, each jurisdiction should have its own will. Now, it's good that you have a planner that works with you across the cross-border planning, right? Because those where you got blind spots that you don't see, you need someone who can actually understand those jurisdictions and be your sounding board, at least during this will drafting and doing that, because each jurisdiction has its own law. Creating one, assuming that is going to apply to everything else, not a good idea. That answer?
Great. Thank you very much. We have another question. Moving along, is a wasiya for non-Muslims? That's the end of that question.
Sorry, Zara, I lost you. I heard only last thing I heard was wasiya.
Yes, the question that was asked, Bassem, is a wasiya for non-Muslims as well?
Okay.
I can answer that question.
Yes, please. Yeah.
It is applicable, but it's not forced. If a person doesn't want to leave a will, a wasiya is basically a will. It's just in Arabic. It's fine, but having one would help everything be running smoothly, and it would help to simply just distribute accordingly to the legal system and the Sharia. But it's not forced. You can choose not to have a will, like the scenario that Bashar gave. That was with no will. That's the division. If you write a will, then things can change.
Thank you.
Thank you,
Just
Jory.
conscious of time and moving along. The next question for the panel is, what are the fees associated with setting up a Cayman entity, and are there any annual fees? What about management fees in the form of a portfolio or account manager as a percentage?
That's Dominic.
Yeah. Um, yeah. Okay, so in terms of, the type of structure I've been mentioning on the call, the fees for setting it up are a combination of kind of legal fees and core disbursements that are payable to the Cayman registrar. So you're looking at around $3,000 on the disbursement side. These are fees that we would have to pay the Cayman government essentially to set up your company. And then the legal fees can really range, for a very, very simple holding company where, the ownership is going to be a single individual. It's going to be managed or directed by a single director. It's only going to need one asset transfer on day one. You're looking at between like $5,000 plus the disbursements. But if going more towards a more common structures, the fees really will vary. And then if you add a will and the probate process on top, it can, go up proportionately. But it's very difficult to determine because I've even had fairly simple holding company setups that have started at around the $5,000 to $7,000 range in terms of legal fees, but they can go up substantially higher. So I would say, look, if you're looking at doing this for the first time and you want to keep it fairly vanilla, think about $5,000 to $7,000 in terms of legal fees, and then maybe $2,000 to $3,000 in terms of disbursements. So it's $10,000 roughly. And as to the second, and there are annual fees. Those disbursements I mentioned, which were around $2,000 to $3,000, it's going to be around $2,000 to keep these things up and running in Cayman, just to have them there. If you need further legal advice during the existence of the entity, obviously further fees may become payable. And in terms of management fees in the form of portfolio or account manager, I'm not too sure what that refers to.
That refers to our side. So for managing
Yeah,
assets
yeah.
there,
So it
yeah.
wouldn't be nothing that I could advise on, I suppose, on that side.
Thank you, Dominic. Moving along, Basim, this question is directed for you. Could you please explain the difference between the 15 million versus the 60,000?
We just addressed that. So the 15 million is the protection, or the let's call it, yeah, this is the protection for a US person or a Canadian resident. How much is being protected against the US estate tax. Once the Canadian resident becomes non-resident, or a person, a citizen of the world, regardless what country they come from, then they get only 60,000 protection. So 15 million only for the US person or a Canadian resident, 60,000 for everyone else in the world. In simple math, 1.1 million portfolio into as a Canadian resident, and the person dies, there is no US estate tax payable because they have the treaty and they enjoy the 15 million protection. And in the same token, the person become non-resident, and as a non-resident, now the 50 million drops to 60,000. So the 1.1 million suddenly becomes fully exposed to the US estate tax, and the graduated rate tax go up to 40%. And this is the part, and the follow-up to this question, the theme of the evening is you need to structure your assets properly, and there's no shortage of options. It all depends on your objectives. We can go something as an offshore structure and the Cayman. We have also the insurance wrappers, where it's a simple process to transfer assets. You have on top, you have all desired estate planning needs being addressed there, and it's a more cost effective because it's not as complex as having the company. So there are options, address all the needs, and the conversation with us really is where things begin.
Thank you, Basim. Moving
You're welcome.
along, this next question has 3 sections. Part of this question has already been answered by Dominic.
Sorry,
but
Zara, can I suggest something? I'm sorry.
Yes.
Do we have lots of questions? Because I'm just watching, I'm respecting everybody's time. I'm just wondering if we have a lot more, maybe we can reach out to them individually, tomorrow onwards. But if we have two more questions, we'll take them.
I think we've got a few more questions. Bassem. Some of them have already been answered, but
Okay.
but I'm just also conscious of time because
Yes.
so maybe for the remainder of the questions, it might be beneficial, as you said, to respond to them separately outside of the session.
Sure. Okay, let's take 2 more questions.
Okay, no problems. I'll do one question, and maybe that could be the last question. Okay, so the final
Sure.
question for the evening is, how are RRSPs,
RRSPs.
yes, in Canada disposed of or transferred to a Cayman holding company, portfolio bond, or a PPLI?
PPLI. Right. So this again, I'm gonna start with this. Yeah, thank you. It's a very good question. Okay. Look, when this an RSP now, well, I'm not speaking to the person, so I need to know this is an RSP or a lira because there's a difference, but nonetheless, the basics are the same. The RSP it's a registered plan, and now let me take me back. Okay, so bottom line, and I will contact you. I'm sure that the name is there. We will contact you within the next couple of days to get more details on this because it's not one of those questions that has a straight answer. But the baseline, an RSP is a registered plan, and withdrawal from RSP will trigger tax, is considered taxable income. And it is, again, I'm assuming you are non-resident, because if you are resident, it's a different game, but I'm assuming as non-resident, so it will be subjected to 25% withholding tax. And so on $1 million, you will leave 250,000 to the bank, to CRA, and then you move the 750. Now, the 750 moving on to a portfolio bond or insurance wrapper. Now, this is the easy part because this becomes an investment, and we go through the investment objectives and this investment recommendation. Now, you cannot move the assets. Maybe the question you're asking, can you roll it? Can you roll over the holdings? Like I have the Microsoft, Apple, and Tesla. Can I roll them into this one? Probably no, you cannot, because you have to dispose of the RSP, satisfy CRA, pay the 25% tax, you take out the cash, and then you buy those stocks within the structure that you desire, be it in the Cayman, be it in PPLI. PPLI is a much bigger ticket price, minimum to get into it, but regardless of the structure, the investment is the easy part. I hope that kind of answers the question. But there's a lot more to talk about in that particular situation. But I'll leave it at this.
Fantastic. Thank you very much, Bassem, and thank you very much to
You're
the
welcome,
guest
Zara.
panel members. That now brings our session for this evening to a close. I wanted to again thank everybody who's joined, to our panel members and to our participants. Thank you very much. As the moderator, it's been wonderful moderating this webinar. Just some final housekeeping before I close up. All the participants will receive a short survey in their email inbox. Could you please take some time out to provide comments, complete that? That provides feedback to Bassem and the team in what you're looking for, what worked well, what could be improved. Also, just to let you know that Bassem does offer a complimentary consultation, and that link will also be in the email that will get issued. So please, if you feel that the session was useful, there's information that's triggered some thought that you feel that would assist with your journey and your planning, please contact Bassem. The link will also be in that email that you can then set up time in his calendar. Finally, I just wanted to
And
thank.
we'll connect directly with the Saudi law firm, Dominic, whatever the need is. This we all work together to assist you with your plans. We don't work
Great,
in
thank you.
silos.
Yes, and then if there's anything else that we can assist you with, please contact Bassem. But on behalf of the panel, thank you very much for this evening, and we hope that you thoroughly enjoyed tonight's webinar.
Thank you, Zara.
Thank you very much. That brings the webinar
Thanks,
to a close.
Thank you.
Thank you very much.
You're
Thank
welcome.
you.
Goodbye.
Yeah.
Okay.
Bye-bye.
Bye.